Hi, this is Leslie Corbley with Libertas Institute here with Sheng with the New Civil Liberties Alliance, and he is a plaintiff's attorney for a case that the NCLA recently brought against the state of Massachusetts. Would you be able to just introduce yourself and let us know the facts of the case?
Thanks, Leslie. Hi. Again, as Leslie said, I'm Sheng Li. I'm an attorney at the New Civil Liberties Alliance. We're a nonprofit, nonpartisan organization that challenges government overreach, and this case exemplifies just that. So what happened was during the COVID-19 pandemic, Apple and Google made available certain codes that allowed state public health authorities to develop contact tracing apps, which is fine. And many states made this available for voluntary download, and many people downloaded the apps. And what the apps do is they stay on your phone and they activate your Bluetooth and use Bluetooth signals that bounce off of other Bluetooth signals to create a log of people you've been in contact with and places where you've been, so that if you have, been infected with COVID, you can report that, and it'll send an automatic signal to everyone you've been in contact with over the past 10 to 14 days, an alert saying they may have been exposed. And all of this is fine. And again, many states did it, and many people voluntarily downloaded it. What Massachusetts did was a little different. First, Massachusetts developed its own app in sometime around April 2021. And there were a lot of complaints. Nobody really downloaded it. There's not a lot of voluntary uptake. You go on the App Store and you see a lot of complaints saying, this only really works if everyone else has it. And honestly, no one's using this app. And so a few months later, sometime in the summer, Massachusetts worked with Google to automatically download a new version of their app onto what looks like over 1 million Android phones within the state of Massachusetts and surrounding states. And nobody consented to having this app downloaded on their phone. And what's particularly insidious about it is that once the Massachusetts app downloads onto your phone, it doesn't appear on your screen like any other app on an Android phone. Instead, you have to go to settings and the See My Apps function, and then you can find there's this app that's developed by the Massachusetts Department of Public Health that takes up about 15 or 20 megabytes of your memory, and it appears to appears to track your contacts and movements. So unsurprisingly, a lot of people found this very upsetting and creepy. And if you go to the second app's Google Store webpage, you'll see thousands and thousands of reviews complaining of just how outrageous this behavior is, how much of an invasion of privacy and property this is by users. The average star rating is something like a 1.5 star, and so what happened was we were contacted with a number of people who objected to this app being on their phone, and a couple of them agreed to let us represent them in filing a class action against the Massachusetts Department of Health for installing forcibly and stealthily installing this app on their phones. And just to clarify, this is not something Google did on its own, Google being a private actor. When Google was asked about this by a reporter back in 2021, Google responded, Google worked with the Massachusetts Department of Health to automatically distribute this app. So this app was developed. If you look at the App Store, it's clearly developed by the Massachusetts Department of Health, and Massachusetts.
I don't mean to cut you off. Would you be able to move just a little bit to your right? A little bit of your face was cutting out of frame. I'm sorry. I just wanted to make sure you knew. Okay, carry on. So
sorry. Yeah, this app was this app was clearly developed by the Massachusetts Department of Public Health, and the department clearly worked with Google to put this on people's phones. So the department's footprint or fingerprints are all over this practice of stealthily installing an app on your phone. And we filed a lawsuit, a class action, at the end of 2022, and that's pending before the district court in the state of Massachusetts right now.
Sure. So thank you for that summary. I appreciate that. Would you be able to give a little bit of background as to how you expect this to move forward in the court system, and whether you expect it to move into appeals, or what sort of the anticipated legal trajectory of the case?
Of course. So right now it's at the very beginning stages. The Department of Health has not yet responded to the lawsuit. They won't be responding until February. When they do, they will either file what's called a motion to dismiss and argue the case is meritless. We obviously would disagree, or they will provide a basis of facts for us to go forward. And assuming we get past the motion to dismiss part, and I think we will, based on we can talk about the legal arguments of why that's the case. But assuming that's the case and we get past it, we move into the phase of what's called discovery. And this will be a very interesting phase because it's where we, the plaintiffs, will get to kind of read some of the documents and talk to and ask questions to some of the individuals involved in the Massachusetts policy and get a sense of why they did this, the extent of what they did, how many phones does this malware really infect? Because the Google store only says over 1 million. Above that, they stop tracking, so it could be anywhere between 1 and 5 million phones. I think there's a category for 5+ million, so they haven't reached that yet. I don't know if there's that many people in Massachusetts or that many Android users in Massachusetts. And so the discovery process will be very useful for that. In particular, it'll let us know what the data is really being used for. If the data that's being the Bluetooth tracking data that comes from the app, how long it's stored, where it's stored, who has access to it, are there people outside of government who might have access to it? Can Google, is it just for the government, or does Google have access to it? If Google has access to it, that could be very problematic because a number of states have sued Google for its location tracking practices of customers, deceiving them into the extent, allegedly deceiving consumers to the extent that Google tracks consumer data. And Google actually settled with those states, including Massachusetts, for a total of something like $400 million. I think Massachusetts' share was something like $10 million. So Massachusetts knows that Google has, allegedly a bad propensity of tracking consumer data, and yet is working with Google hand in hand in installing this app that does just that.
So, given what you've just mentioned related to Google's lawsuits that they have settled and the actions of the Massachusetts government, what is your perception of the relationship between these large technology firms and government actors as far as maybe not necessarily being forthright as to what practices they're engaging in?
Well, we've seen a disturbing pattern. I guess in the news it's the Twitter files, right, of the government working with big tech companies to accomplish things that the government by itself can't do, but working through the big tech companies. And we think this fits in within that pattern. Certainly the government itself can't be installing software without your knowledge on your computer devices. In fact, there's a federal law where people go to prison for that. And but yet it's working through Google to do just that. And to install, it's not a Google software. Massachusetts Department of Health put their label on it, put their name on as the developer of the app, and Google confessed that they worked with the Massachusetts Department of Health to put this on your phone, or maybe not yours, but the phones of people who live in Massachusetts. And might I add, many people who don't live in Massachusetts, because people we've talked to have said, they might commute into Massachusetts. One of our clients is a commuter who lives in New Hampshire. Others vacation there, and others simply just drive through, from maybe Maine to New York, and then they find their this app on their phone months later. So it appears, again, maybe through the discovery process, we'll figure out exactly how the state is doing this, but it appears they target you based on your geolocation. If you're in Massachusetts for some period of time, this app may appear on your phone.
Sure. So correct me if I'm wrong, but it seems that being able to dig into the facts of this would be really helpful in answering what likely are some slippery questions. For instance, how are they accessing the geolocation data? Are they capable of, a question I would initially have is, are they capable of re-downloading the app in the event that you delete it? Things like that.
So that we don't know all the facts, but we do know, in fact, that many people have reported to have deleted the app only to find it on their phones once again. So it does seem like there is a periodic re-download practice happening. But there still remains a lot of questions that we don't have the answer to. And frankly, we don't need the answer for those at this early stage in the lawsuit because we're expected to learn them in the discovery process. And so again, some of those questions are, where is the data going? Is it kept for a certain number of days, weeks, months, or is it all being, does the Massachusetts Department of Health somewhere have multiple years of data on its citizens, which would be just disturbing to the least, and who has access to it? You hear about all these. Is it being, God forbid, commercialized in any particular way, sold? Because a lot of advertisers would love to have that sort of information.
Are you aware of or concerned that there may be some kind of a financial tie between the state and Google that incentivizes Google to want to work with governments in this capacity?
Well, I mean, I can't speculate on that, and I really don't know. And certainly, it probably not. Without any hard evidence, I wouldn't think so, especially given their antagonistic relationship in the state's lawsuit against Google. So there's definitely some hostility there on certain issues. That said, private companies are always interested in being on the good side of their government regulators, whether that's the federal government or state government. So it's unsurprising that a private company like Google would welcome the opportunity to collaborate with states like Massachusetts and other states. When the opportunity comes, because they want to curry favor with their government and be on the good side of them. So it's not surprising that when the Massachusetts, we don't know exactly what kind of pressure Massachusetts exerted on Google, but when they did, it's not surprising that Google acceded to it, and did what their state regulators asked them to do.
Sure. So as far as we've gone a little bit over the facts of the case, like what factually arose that caused this lawsuit to be filed. Can you just go a little over and explain the causes of action that you are pursuing in the lawsuit?
Yeah, I mean, we have many counts of action, but really they're largely put into three broad buckets or categories. The first is the Constitution's Fourth Amendment, which prohibits the government from conducting unreasonable searches. And that's really, and the Massachusetts has a separate and really equivalent provision in its constitution. So, that's one category of our claims. And generally, before you can conduct a search on someone's effects or property, you need a warrant or some other exigent circumstance. And there's really no exigent circumstance here. Exigent circumstance, like when the police is chasing someone and burglar runs into your house and the police runs into your house to chase the burglar. That's fine. But in this case, there's none of that. Nor is there any warrant, and it's indisputable that the phone is your effect. You own it, and the Supreme Court has said that any sort of search of your phone, of your property, even minor, like a dog sniff. There's one Supreme Court case involving a dog sniff of someone's yard, and the Supreme Court said that's enough to be a search that normally requires a warrant. There's a case out of the Sixth Circuit where a 3-judge panel said, when the parking supervisor or the parking inspector chalks your tire, puts a chalk mark on the parked car's tire, and then comes back in 2 hours and sees there's the same car with a chalk mark, and then writes a ticket, that's a search because it's putting the police is actually touching your property. And there's no different here. Your Android is your property, your Android phone, and the government is going in and putting its listing device or its tracking device, its software. It doesn't even matter what the software does. It matters that the software searches conducts any kind of. Sorry, let me go back. This Android is your property, and it doesn't matter that the government intrusion might be somewhat small because it's only 15 or 20 megabytes compared to the vast memory storage space of your phone. But if it's even an iota of an attempt to gather information about you, that's a search. Think of, again, the tire chalking example. This certainly crosses that threshold. And the second category is somewhat related in that we think it's a violation of your property rights. In the government, the government can infringe on its citizens' property rights, but the Fifth Amendment of the Constitution says it must provide just compensation. If it takes your property, the government has to pay you. And again, the infringement can be small, minute, negligible. It doesn't matter if it's any kind of infringement that is a compensable takings under the law. And the key case on this is the Supreme Court said a New York regulation requiring a landlord install a small cable box, just, within the relative to the size of an apartment, negligible, just a few square inches, that was a taking for which the landlord deserved just compensation. And here too, sure, your phone might have many gigabytes of memory, but this app takes up 15 megabytes of that. And it's your property. Every one of those megabytes is your property, and the government deprived you of 15 of them or 20 of them. I forget exactly how big it is, but it's somewhere in that range. And that, the government has to compensate you, and maybe the compensation is not significant on a per person basis, but when it does this to, 2, 3, 4 million of its citizens, that could be a very large number. And the third category is this concept of ultra vires action. And the idea is that we live in, a system of limited government where the government has no power to act unless the legislator expressly authorizes the government to do something. And here, there's nothing in any of the statutes that establish and empower the Massachusetts Department of Health that allows them to go and gather information about its citizens in this way. And so, in the absence of that authority, what the Massachusetts Department of Health is doing is outside of its scope, of its power, and therefore unlawful. And we are asking the court to stop it for that reason.
Sure, I think that. Thank you for providing that explanation. That really sums up certainly what I read in your complaint, which was very well drafted. Fantastic complaint. And I just am curious if you can dig a little bit more into this connection between privacy and property rights, because it seems as if you're really connecting those two ideas, right? You can't have, there's unreasonable searches you're saying happening here, which is kind of an invasion of your privacy in a way. And then there's, of course, this issue with the property rights as to your device.
Yeah, and the connection, I think, between privacy and property goes back all the way to the founding, and the concept of what the Fourth Amendment protected was in many ways connected to your property rights and your right to exclude trespassers. Particularly, the government generally can't trespass on your property and look into your affairs without probable cause and a warrant and such. The privacy and property became untethered a little bit in the middle of the 20th century, where Fourth Amendment doctrine took maybe a left turn or veer in a particular direction. In a number of cases where the standard became the reasonable expectation of privacy, which sounds nice, but it's a very difficult to understand standard, and courts have had trouble applying it. More recently, the standard has returned, and now we're actually in a weird situation where there's two tracks of assessing whether your privacy has been invaded. One is whether your reasonable expectation of privacy has been violated, and two is whether your kind of property has been violated. And it's a welcome development, I suppose, because there's two different ways of proving a privacy violation that actually may guarantee more robust privacy protection in the long run. And here we think there's actually a privacy violation occurs in both ways, or potentially in both ways. The first is under the reasonable expectation of privacy. The Supreme Court has said, kind of, even though if everything you're doing is in plain sight, generally you don't have a reasonable expectation of privacy to that. But a history of your movements, even if every step of the way is in plain sight, if that is gathered, that could violate your reasonable expectation of privacy, because you may expect to be seen in plain sight. You don't expect to be followed, 24/7 or hours and hours at a time. And so it's very important for us in discovery to figure out the extent of data that's actually gathered about a person's whereabouts, contacts, and whether or not that data, when aggregated, can kind of create a timeline that's accurate enough and comprehensive enough to violate someone's reasonable expectation of privacy. Sorry, go ahead.
No, I was just curious what you would say to, what I imagine some of our listeners, or certainly if I were just a man on the street, I would be thinking, wow, that's fantastic that we may have these two tracks that could potentially protect our privacy rights at the high level of the Supreme Court. Most cases don't make it to the Supreme Court. And so at a functional level, when your rights maybe have been violated, or there's concerns that could be happening, what would you tell the average person who's concerned with the what the functional technology capacity of technology can do, paired with the reality that then makes it easier, for some of these invasions to occur on the front end, right
Yeah,
before
I
say the
think
Supreme Court can stop it.
that's definitely a real concern. And in many ways, the law develops slowly and the technology moves very fast. And so we're seeing in the law slowly catch up to technology progress, but the way the technology moves is always a little bit ahead. So there's always a new frontier of what potential privacy violations that's happening that we just don't have the law for. And I think that's why it's important for people who have who feel they've suffered some sort of privacy violation, speak up, protest, and even file lawsuits. And it's particularly important to do so in the civil context because what often happens is these lawsuits, these issues will, if they don't appear first in the civil context, which is what's going on here, what's going to happen is they're going to appear in the criminal context where the cops will have used some sort of high-tech surveillance method and caught a bad actor doing something bad. And then you're before the court, and the court's put this in a precarious position of either saying, well, this new surveillance technology is okay, or letting the bad actor, which everyone agrees is a bad actor because he was caught red-handed with this new surveillance technology, we're letting that person go, or letting that person off. And that's a way of, it's a very difficult position for the court, and it's a way of how the law sometimes develop in bad ways because of these tough factual aspects to it. When it's involved in the criminal context, and when it's involved in the civil context, you don't have this pressure of, if I find a privacy violation, a murderer goes free or a drug dealer goes free. And so I think it's important to get some of these issues ventilated in the court system in the civil context before in the criminal enforcement context.
I think you're especially right about that, given where we are right now, right? I would say right now in society, it would be considered fairly drastic for the government of Massachusetts to do what you're describing, right? Of downloading software onto a device without a user's knowledge or consent. But as I think history has shown, our expectations of privacy do evolve. And I think to some degree, we have evolved too far away from, to what extent should an individual be able to easily secure their privacy, right? I would say right now that's pretty difficult. Like the Supreme Court ruled, that it's now functionally impossible not to have your movements tracked via GPS, right, and Bluetooth signaling of your cell phone, which I seem to factor into their decision in Carpenter regarding your cell site location information. So with that being said, again, as technology is moving in one direction, what would you say to those who are concerned with the government attempting to exert greater control over digital devices, which it seems like this case would fall into that pattern?
There, maybe swing back to the property prong of the Fourth Amendment protection, because the good thing about the property prong is that it doesn't evolve. It's not based on expectations. There's no squishy factor. It's a fairly bright line test. Is this my property or your property? Is this or the public property? And with respect to your phone, it's quite simple. Everything in your phone is yours. There could be, I suppose you might dispute, well, if it's software, it's merely digital. Maybe that's different from physical property, but let's not kid ourselves. An app is not some metaphysical thing. It's still, at the very essence, lives in electrons, which have some mass, a small amount of mass, as physicists will tell you, but it's not nothing. And if you own those electrons, and if the government interferes and trespasses on them, that's an interference with your property right. And again, it's not unlike the reasonable expectation test. It's not you're not balancing anything, you're not surveying anything, you're not saying, oh, this is so minor. It's just a very bright line test. Was the line crossed or not? And that might provide, actually, it's interesting, might provide a better safeguard of people's privacy than an expectations-based test in an age where technology often outpaces kind of legal doctrines.
Sure. No, I think you're pretty much spot on there. As far as I'm curious what you make of the distinction between property, which I think is, you're right, it's pretty clear that you own your phone. It's a very tangible physical object. What do you make of situations that may be a little less clear? For instance, if you have a account on a cloud, I know that that can make the property rights claim a little more squishy, perhaps.
Yeah, and so there's something called the third party doctrine. I don't want to get too, which is not implicated here because it's very clear you own your phone. Third party doctrine, which is like the idea is if you uh, let's say have an account with another business and they keep business records and financial records about you, can the government search those records from the third party instead of through you, even though the documents are clearly about you? And the Supreme Court in the financial bank context has said, well, that's permissible because you don't have an expected privacy to just do stuff that the third party owns. But I think that's bound to change as well, because again, technology has gone to the point where everything we have, all our information, is held by some third party or another through these contractual arrangements, and it gets very uncomfortable to say that. That you don't have any reasonable expectation of privacy. You don't have any privacy protection to any of that. And in Carpenter, the court did not overturn its third-party doctrine, but did say it didn't apply to cell site information, which is obviously information that your cell phone company has. So it's created, it recognized it doesn't work in these kind of new high-tech environments. And so I think that doctrine it's evolving as we speak. It may evolve more. And be interested in seeing how what direction it goes in.
Yeah, that touches on, again, some of the things I think most people aren't thinking about as they live their daily lives, but that are really important, which is there's a legal distinction between, the information that you hold in the cloud and the information that's stored locally on a device. So local storage is more secure and more difficult to breach for a government actor than what's stored in the cloud. And I actually think it's really important what you brought up in relation to doing this in the civil context rather than the criminal, because most people, I don't think, have in their head a reason to be thinking about some of these legal distinctions, right? Because they're not under criminal investigation, generally not interfacing with a regulatory body in a capacity that would lead them to think that there's, that they're in danger, or that there could be any problem maybe with how some of these technological arrangements are set up. So I just am curious if you have any closing thoughts related to, moving forward, what some of the possible legal and cultural implications of having a higher tech, as we move into a higher tech, more digital blended model of life, what some of the potential problems are and what maybe some solutions could look like.
Well, I do think certainly technology moves very fast and presents certain dangers, but I do think the law ultimately does catch up and does a pretty good job of dealing with it. Where I do think we need to be wary is the increasing phenomenon of governments outsourcing their practices to private groups that, on their face, don't face the same sort of constitutional restrictions that government actors do, and so that's, I think, if anything comes out of this case, I think the thing that I would most want to come out of this case, I think, would be a more clear, way of establishing when government and private actors collude or collaborate in particular ways, when that is state action that's subject to constitutional restrictions. Because you can have the best Fourth Amendment law, the most protective, but it won't really matter if the government can simply partner up with a private organization like Google or whatever and learn information about its citizens that way.
What would you say to consumers in regards to their behavior and what that can do to push technology towards more privacy-centric versus less privacy-centric models?
Well, I think consumers, are free. Like we think consumers should be free to do whatever they want. And certain consumers are very keen on protecting their privacy, others less so. And as long as companies are forthright about, the extent to which they protect their consumers' privacy and public information, we as an organization don't have a problem if, for example, if you really want cheap email service, and as a result, you're happy to, in exchange for cheap email service, allow Google to data mine your emails, that's a decision I think you should be free to make. Now, if Google deceives you about the extent to which it's taking your private info, that's a problem. But if everyone is forthright and honest about it, we think you can trade away your information and say, Google, I'll let you know how many times I email my sister so that you can sell that information to Amazon about when I should buy a Christmas present for her kids or something. I don't know. And that's fine. And in exchange, I get very cheap email service with great storage and great service. And that's a great decision I can make. What's problematic is potentially is when the government gets involved in that relationship, and Google is not, it's taking my information and giving it to government actors, or when the government pressures Google to do so without letting me have an opportunity to be involved and stop that. And I think that's where maybe the kind of new frontier of kind of litigation and legal issues might reside in the near future.
Great. Well, thanks so much for joining us. We really appreciate it. We really appreciate hearing updates on this lawsuit and the facts of what occurred and what led, to the lawsuit being filed. We would love to hear more from you in the future if that's something you're willing to.
Oh, definitely. Yeah. When things happen, Thank you for this opportunity, Leslie.